The Valley Current.
Imagine for a second, right, that you have just poured years of your life into this massive project.
Oh, sure.
I mean, we are talking millions of dollars, countless sleepless nights, and quite frankly, your entire heart and soul.
Yeah, you just live and breathe the thing.
Exactly. You know every single detail. You know the footnotes, you know the margins. I mean, you know the origin story of every single decision that was made.
Total, absolute mastery.
Right. You have achieved total mastery over this domain. But here is the terrifying part, and really the hook for our deep dive today. What if that exact mastery, that total suffocating immersion in the details, is actually your biggest liability?
Which is such a counterintuitive thought.
It is, because what if knowing everything makes you entirely blind to the one thing that actually matters?
It is a profound vulnerability, honestly, because, we are culturally conditioned to believe that expertise and proximity are the ultimate advantages.
Right, like the closer you are, the better you see it.
Exactly. The assumption is that the closer you are to a problem, the clearer you see the solution.
Well, that assumption is exactly what we are going to tear apart today.
I'm ready.
We are using this fascinating document from the Litigation Strategy series, which is published by Computer Law Group, LLP.
Yeah, it's a great piece.
It is a special briefing from August 2026, and it's titled The Appellate Specialist's Edge: Why Consult Neutral Expert Eyes, Pre-Trial, Post-Trial, and Pre-Appeal.
Authored by Jack Russo.
Yes, authored by Jack Russo, who is the managing partner there. He's a certified appellate specialist and a NEDA master jury trial advocate.
A lot of credentials there.
A ton. And through this briefing, we are exploring a concept called the advocate's paradox.
Right, the advocate's paradox. It's the idea that the fierce, brilliant trial lawyer, the one who knows the case better than anyone else, structurally creates a dangerous blind spot for themselves.
And we're going to examine how bringing in a highly specialized, neutral second set of eyes can radically alter the outcome of these, incredibly high-stakes disputes.
It changes everything.
It really does. But before we get into the heavy mechanics of the legal system, I want to emphasize why this matters to you, the listener. Even if you never, ever plan to set foot inside a courtroom.
Oh, absolutely. The applications go way beyond law.
Right, because understanding how world-class experts systematically debias their own decision-making under immense pressure, well, that is a masterclass in strategic thinking.
It's a framework you can use anywhere.
Exactly. You can apply this framework to a board meeting, to a medical diagnosis, or, even to how you navigate a major family decision.
It's universally applicable.
It is. I do need to state our standard rule for these deep dives, though. We are strictly synthesizing the strategies, the statistics, and the frameworks presented in this specific CLG technology and IP briefing.
We're just looking at the source material.
Right. We are exploring the underlying logic of these concepts. But to be clear, nothing we discuss today is a substitute for actual legal advice.
Yeah, we are analyzing the strategic architecture of the document. We're mapping out the behavioral economics and the game theory of high-stakes litigation rather than offering counsel.
Perfect. So let's jump right into the psychological root of the problem. Why do incredibly brilliant people make terrible bets?
That's a great question.
Because the briefing points out that every seasoned trial lawyer carries this quiet occupational hazard. The deeper their mastery of a case, the harder it becomes to see it as a stranger, or more importantly, a 3-judge appellate panel will eventually see it.
And, the briefing does not just treat this as some vague philosophical notion. It roots this heavily in behavioral science.
Okay, lay some science on me.
Well, the author points to experimental work with sitting judges, specifically citing research by Guthrie, Roklinski, and Wistrich from 2001.
Sitting judges, like the people in the robes.
The exact people in the robes. That research documents that even highly trained decision makers, judges whose literal job description requires objectivity, they suffer from severe cognitive biases.
Wait, really? What kind of cognitive biases are actually operating inside a judge's mind?
The study highlights 3 major ones. You have anchoring, framing, and hindsight effects.
Okay, let's break those down. What is anchoring in this context?
So anchoring occurs when a judge relies too heavily on the first piece of numerical information they receive.
Like, say, an initial damages demand.
Exactly. A huge damages number gets tossed out there, and it just pulls all their subsequent calculations toward that number. Their brain anchors to it.
Wow. Okay, and framing.
Framing is how the presentation of information alters the judge's risk appetite. Like, whether a settlement is described as a gain or a loss completely changes how they view it.
Even though the math is exactly the same.
Right, the math doesn't change, just the emotional packaging. And then there's the hindsight bias.
Ah, the classic I knew it all along phenomenon.
Yeah, that's the one, where a judge looks at a bad outcome and assumes it was completely predictable. They completely ignore the massive uncertainty that existed at the time the actual decision was made.
So if sitting judges, who are supposed to be the absolute umpires of the system, fall prey to these cognitive traps, I mean, it is easy to imagine how deeply a trial advocate is impacted by that.
Oh, immensely. Because a trial lawyer is not an umpire.
Right. They're an active combatant fighting for one specific side.
Exactly. The trial lawyer's brain is naturally filling in the gaps with years of discovery, depositions, and, private client meetings.
They have all this backstory.
Yes, they have the emotional context of the entire war, but the appellate court is only going to see a cold printed record.
Just stacks of paper.
Right. They do not have the emotional context. They just have the transcript.
The briefing actually cites two former members of the bench, Judge Margaret M. Morrow and Justice Lori D. Zillon, who highlight that this total immersion makes lawyers lose their objectivity.
It's a real occupational hazard.
But I have to push back on this premise for a second.
Oh, okay, let's hear it.
Sure, maybe it clouds risk assessment.
Yeah.
But if my bulldog lawyer's zeal intimidates the other side into settling, hasn't that zeal paid off? I mean, if I hire a litigator, I want a fanatic. I want someone who believes in my case to their absolute core. Why on earth would I dial that back by bringing in a neutral third party who might, water down that aggression?
That is a totally fair question, but you are touching on a crucial distinction here. It's the difference between outward performance and internal strategy.
Outward versus internal. Okay.
Right. Zeal is absolutely essential for the outward performance of advocacy. You want that bulldog energy in the deposition room, and you certainly want it in front of a jury.
Of course. That's what you pay for.
Exactly. The problem arises when the lawyer brings that same zeal into the war room to make internal strategic bets about the future of the case.
Ah, I see.
Zeal is a weapon, but it is a terrible compass.
I love that phrasing. A terrible compass.
It really is. And to show you how dangerous this is, the briefing cites the staggering empirical finding by Kaiser, Asher, and McShane from 2008. They looked at large sample studies of failed settlement negotiations.
Okay, so what happens when they analyze the data on cases that failed to settle and actually went to trial?
They found a persistent, measurable miscalibration.
Meaning what?
Meaning parties who reject a settlement offer and choose to proceed to trial frequently end up vastly worse off than if they had just taken the rejected offer.
Wait. So the trial team is so blinded by their own zeal, so utterly convinced of their righteous position, that they walk away from guaranteed money on the table, put their client through the agony and expense of a trial, and mathematically end up with less.
Yes, that is the systematic miscalibration the data reveals.
That is wild.
It is. The trial team, infused with that necessary zeal, they just cannot accurately price the risk of losing. They treat their best case scenario as most likely scenario.
They believe their own hype.
Exactly. They mistake their own persuasive performance for an objective guarantee of victory.
So if litigants and their lawyers are systematically misjudging reality like this, the briefing argues that bringing in an outside calibrator, a neutral specialist, is not a luxury.
No, it is an empirical necessity.
Right. The question is not whether you know your case. The question is whether you can still see it the way the reviewing court will.
And to understand how the reviewing court sees it, we have to look at the baseline math of the appellate system.
Let's get into that math, because the statistics presented in this briefing are, well, they're a brutal reality check.
Brutal is the right word.
If I am a lawyer or a client who just lost a grueling trial, my immediate visceral instinct is probably, we are taking this up, the judge was biased, the jury was confused, we will appeal to a higher court and get our justice.
Which is such a natural human reaction.
Of course it is. But the briefing outlines the baseline rates for appeals, and they require a total paradigm shift for anyone with that mindset. Let's look at the state level first, specifically California.
Okay, California.
In fiscal year 2023, there were 2,601 civil appeals terminated by written opinion.
That's a lot of appeals.
Right. Out of those 2,601 cases, how many appellants actually got the justice they were seeking?
Well, an overwhelming 70% of those cases were affirmed in full. 70%.
Yes. The appellate court looked at the massive stacks of paper, read the arguments, and basically said the trial court got it right. The judgment stands completely.
That is a huge wall to climb over.
It gets worse. Another 9% were affirmed with modification.
Meaning what?
Meaning the court judgment survived, perhaps with a minor mathematical tweak to the damages, but the underlying win was upheld.
So essentially, 79% of the time, the trial court's decision is standing in a highly meaningful way.
Exactly. Only 17% were actually reversed.
17.
And the remaining 4% were dismissed entirely, often just for procedural failures.
17%. I mean, if you were pounding the table screaming, "We're going to appeal," you were statistically betting millions of dollars on a 17% chance of success.
And those are just the state numbers, verified by the Judicial Council.
Wow.
If you move over to the federal system, the math gets even tighter.
Tighter than 17%. Oh, yeah. The national average reversal rate across the federal courts of appeals for fiscal year 2024 was a mere 7.6%.
7.6%. Betting on a 7.6% chance is not a legal strategy. I mean, it is a lottery ticket.
It really is. It fundamentally changes the conversation a lawyer needs to have with a client. The briefing notes that these proportions are stable year over year. Reversal is the exception.
Right.
The system is designed to uphold trial court judgments, not to tear them down.
And the statistics are not just generally bad for appellants. They're actually heavily skewed depending on who you are in the lawsuit.
Yes, there's a huge asymmetry.
The briefing cites an empirical study by Eisenberg and Hayes from 2015 that reveals this massive structural asymmetry in the legal system.
That study looked at state court trials taken up on appeal, and they discovered that defendants' appeals succeed at roughly twice the rate of plaintiffs' appeals.
Let me make sure I'm visualizing this correctly.
Okay, go ahead.
So, scenario 1. A plaintiff sues a corporation, wins a massive verdict at trial, and the corporate defendant appeals.
Got it.
Scenario 2. The corporate defendant wins a trial, and the defeated plaintiff appeals.
Right.
The defendant is twice as likely to win their appeal in either scenario.
Yes. The numbers in the study showed roughly a 41% reversal rate when defendants appeal, compared to only about a 21% reversal rate when plaintiffs appeal. The researchers actually coined a term for this phenomenon, plaintiphobia, in the state courts.
Plaintiphobia. That is a staggering disparity.
It really is.
I mean, if I'm a plaintiff and I just won a huge jury verdict, I am probably popping champagne with my lawyers. I feel invincible.
You're on top of the world.
But the data says there is a 41% chance that my hard-fought victory is going to be completely wiped out by the appellate court.
That is the exact blind spot the briefing is warning about. And furthermore, jury verdicts are statistically reversed more often than bench trials, where a judge alone decides the case.
Really? Why is that?
Appellate judges are seemingly more skeptical of juries than they are of their fellow trial judges.
That actually makes sense. So synthesizing these numbers provides a dual lesson for anyone involved in a dispute.
Right, two sides to the coin.
If you are the would-be appellant, the person who lost and wants to challenge the ruling, you need profound humility. You're fighting an incredibly steep uphill battle. The presumptions of correctness baked into the system are immense.
Absolutely. And on the flip side, if you hold the judgment, if you are the victor, you cannot afford to relax.
Not for a second.
You are holding a highly valuable asset, but there is a 17 to 20% baseline risk, and maybe up to 41% if you are a plaintiff facing a defending appellant, that your asset will just evaporate.
Which is terrifying. So if the baseline odds of winning an appeal are so low, the immediate question becomes, how do appellate judges decide who makes up that lucky 17%? It's not random.
Definitely not random.
The briefing points out a major public misconception here. Appellate courts do not retry cases. They do not bring the witnesses back in to testify.
This is perhaps the most dangerous misconception among clients and even some trial lawyers.
They think it's a do-over.
Exactly. They think it's a second trial. An appellate court is not going to reweigh who is more believable. They are simply checking the trial court's work.
And they check that work using very specific legal filters, which are known as standards of review.
The standard of review is essentially the lens through which the appellate judges look at the trial record.
It's the lens. Okay.
And the standard of review is frequently more determinative of the outcome than the actual underlying fairness of the case. The briefing breaks down the three primary lenses.
Let's go through them. The first lens is called de novo.
Right. De novo translates to from the new, or a fresh look. This lens is applied exclusively to pure legal rulings.
For example?
For example, if the dispute is about how to interpret a specific clause in a business contract or how to apply a specific statute.
Okay, pure text. Pure law.
Exactly. When an appellate court uses the de novo lens, they give zero deference to the trial judge. They look at the text of the contract, they look at the law, and they decide for themselves what it means.
So the trial judge's opinion doesn't matter at all in this case?
Nope. If they disagree with the trial judge's interpretation, they reverse it. It is the most favorable standard for someone trying to overturn a decision.
So if your grievance is about a pure legal interpretation, you actually have a fighting chance.
You do.
But then we reach the second lens, which the briefing suggests is the absolute highest hurdle in the law: substantial evidence.
Yeah, this one is tough. This lens is applied to factual findings.
Like who did what?
Right. Did the employer know about the safety defect? Did the driver run the red light? The appellate court was not in the room to see the witnesses sweat or stutter on the stand. Therefore, they apply the substantial evidence standard.
And what does that actually mean mechanically?
It means that even if the three appellate judges read the transcript and think to themselves, we completely disagree with this jury, we would have voted the other way, it does not matter.
Wait, it doesn't matter what the judges think?
No. If there is any substantial evidence in the record to support the jury's factual finding, the ruling survives.
Any substantial evidence. So theoretically, if 90% of the evidence points toward the defendant being innocent, but 10% of the evidence points toward guilt, and the jury chose to believe the 10%, the appellate court will not touch the verdict.
They defer entirely to the fact finder, provided the finding isn't completely baseless or physically impossible, of course.
This maps perfectly onto the NFL's instant replay system.
Oh, I like this. How so?
Well, the de novo standard is like when a head coach challenges a rule interpretation. The referee in the replay booth just reads the rule book. The ref on the field gets no deference. It is purely about what the text says.
Right, that's exactly it.
But the substantial evidence standard is like a diving catch on the sideline. The ref on the field calls it a catch. When they go to instant replay, the governing rule is that you need incontrovertible visual evidence to overturn the call on the field.
Yeah, you have to prove it's totally wrong.
Exactly. If the replay is murky, if you can't quite tell if the receiver's toe is touching the white line, the call stands. Even if the announcers and the fans think he probably stepped out, because the evidence to overturn isn't incontrovertible, the system defers to the person who is standing on the field.
That is an incredibly accurate way to visualize substantial evidence. The trial judge or the jury is the referee on the field. If the factual record is murky or conflicting, the call stands.
Okay, so that's two lenses. The third lens is abuse of discretion.
Right. This lens is used for things like evidentiary rulings.
Like what gets shown to the jury.
Yes. Like whether the judge decided to let a certain controversial email into the trial or case management decisions, the trial judge is given broad leeway to run their own courtroom.
So they have a lot of power there.
A lot. The appellate court will only reverse these decisions if the trial judge made a clear, undeniable abuse of power. The decision has to be so arbitrary or capricious that it exceeds the bounds of reason.
So two different appeals can have the exact same level of grievance, the exact same amount of perceived injustice by the losing party, but they will have radically different odds of success depending purely on which of those three lenses applies to their specific complaint.
Exactly. Sorting your trial issues by which lens the appellate court will use is the single highest leverage exercise in appellate triage.
I can see why.
A specialist forces you to do this before you spend a dime printing an appellate brief.
And the briefing highlights a massive caveat here that trips up even experienced trial lawyers. Let's say you actually managed to prove the trial judge made a genuine error.
Okay.
You prove they abused their discretion, or they got the law wrong under the de novo review. The author, Jack Russo, and Justice Cynthia Aaron both emphasize that proving an error means absolutely nothing unless you can also prove it was a prejudicial error.
Yes. The legal system operates under a doctrine called harmless error.
Harmless error.
Think about it. A trial is a chaotic, messy human endeavor spanning days or weeks. Mistakes happen in almost every single trial. The appellate court knows this.
So they expect errors.
They do. Their governing rule is, we will not reverse a judgment unless the error likely affected the actual outcome of the case.
So if the trial judge wrongfully excluded a piece of evidence, the appellate court might look at it and say, yes, The judge was wrong to exclude that. However, even if that evidence had been shown to the jury, you still would have lost because of all these other overwhelming factors.
Exactly. They stamp it as a harmless error and affirm the judgment.
Justice Aaron noted that trial attorneys, deep in the advocate's paradox, tend to treat any trial court error as a guaranteed reversal.
Because they're so close to it.
They get so emotionally caught up in the injustice of the mistake that they fail to ask the mechanical question. Was it prejudicial? Did it actually change the final result?
They're so close to the painting they can only see the one brush stroke that is out of place, while the appellate judges are looking at the entire canvas.
That is a great visual.
Knowing these harsh realities, the terrible odds, the strict lenses, the harmless error rule, the briefing maps out 5 distinct windows across the life of a dispute where an appellate specialist can intervene to change the trajectory.
And the most counterintuitive part is that the first 2 windows happen long before an appeal is ever filed.
It's so true. Most clients assume you only call an appellate lawyer after you lose a trial.
Naturally.
But the strongest theme uniting the bench veteran commentary in this briefing is the power of early timing.
Let's examine window 1. Pre-trial. The briefing calls this the highest leverage point.
Yes, window 1.
Justice Cynthia Aaron conducted hundreds of early neutral evaluation conferences during her time as a magistrate judge. Her insight is that appellate perspective matters most before there is anything to appeal. How does that actually play out in a real case?
Well, the briefing mentions a specific pretrial mechanism called a demurrer.
A demurrer. Let's walk through the mechanics of that.
Okay. Imagine a plaintiff files a lawsuit. Before the case even gets going, the defendant's lawyer files a demurrer. Mechanically, they are telling the judge, even if everything the plaintiff claims in this document is completely true, they still haven't broken any actual laws. Throw the case out.
So even if I did what you said, it's not illegal.
Right. Sometimes a trial judge will agree and sustain the demurrer without giving the plaintiff leave to amend.
Meaning the plaintiff is not allowed to rewrite their complaint to fix the issues. The case is instantly dismissed.
Right. The defendant wins without having to go through a trial, and they celebrate a massive cost-saving victory.
High fives all around.
But an appellate practitioner who reviews huge volumes of these specific outcomes knows a structural secret. Judgments where a demurrer is sustained without leave to amend are frequently reversed on appeal.
Wait, really? Why are they reversed so often?
Because the appellate standard of review is incredibly generous to plaintiffs at that very early stage of a lawsuit. If there was any reasonable possibility the plaintiff could have amended the complaint to state a valid legal claim, the appellate court will reverse the trial judge and send the case back down to start over.
Oh, wow. Let's look at the timeline of that mistake.
Yeah.
The defendant spends a small fortune winning the demurrer.
Right.
The plaintiff appeals. It takes 2 years for the appellate court to review it. The appellate court says the trial judge should have let them rewrite the complaint, and the defendant is sent right back to square one, having lost 2 years and tens of thousands of dollars.
A massive waste of resources for both sides.
So if you bring an appellate specialist into window 1, what do?
They look at that early victory and say to the defendant, do not fight this. Let them amend the complaint. You are going to lose this on appeal anyway, so don't buy a 2-year delay.
Wow.
They saved the client a massive futile motion cycle simply by pointing out the future reality.
They are fixing the future before it happens. Okay, let's move to window 2. During trial, the briefing uses a phrase here that feels central to everything we're discussing. Appeals are won and lost on preserved error.
This is the strict mechanical reality of the appellate system. If your trial lawyer does not clearly object to an error during the trial and state the specific legal ground for that objection on the record, the error is legally forfeited.
You cannot complain about it on appeal.
No, you can't.
Even if the judge made a terrible, highly prejudicial error that ruined your case.
Even then, the logic of the system is that you must give the trial judge a fair opportunity to fix their mistake in the moment. If you stay silent, you waive your right to complain later.
So window 2 involves having an appellate specialist actually sitting in the courtroom during the trial.
Right. But they are paying attention to entirely different things than the trial lawyer.
Because the trial lawyer is watching the jury.
Exactly. They are reading body language. They are orchestrating the dramatic arc of the witness examination. They are focused on persuasion.
And the specialist?
The appellate specialist is monitoring the plumbing of the case. They are tracking objections, they are scrutinizing the jury instructions, and they are making sure offers of proof are fully articulated.
Let's pause on offers of proof. What does that actually look like in a courtroom? Is the lawyer just raising their hand and complaining to the court reporter?
Well, mechanically, an offer of proof happens when a judge refuses to let a piece of evidence or testimony into the trial.
Yeah.
Say the judge tells a witness, you cannot answer that question. The trial lawyer can't just accept it and move on. They have to pause the proceedings, often sending the jury out into the hallway, and then put on the record exactly what the witness would have said if they had been allowed to speak.
Ah, so they're building a hypothetical record for the appellate court.
Exactly. Proving that the excluded evidence was important enough to change the outcome.
Because if you don't do that, the appellate court later says, we don't know what the witness was going to say, so we can't tell if the judge's mistake mattered. You lose.
Right, they can't mind read.
Jack Russo uses a striking metaphor for this in the briefing. He says the specialist is using their ears to hear the future transcript, not the present performance.
I love that line because when a witness is testifying, the trial lawyer is listening to the tone of voice and the emotional resonance. But the appellate specialist is mentally transcribing those spoken words onto a cold piece of paper asking, how will this text read to 3 appellate judges a year from now, who cannot see this witness crying, who cannot see the dramatic pause?
It is like watching a highly emotional stage play, but instead of enjoying the acting, you are frantically making sure the script is perfectly formatted.
Yes.
Because the critics who will decide the fate of the play will never see it performed. They will only ever read your script.
That's a brilliant way to put it. Having that specialist in the room is inexpensive insurance against the most devastating appellate tragedy. Having a perfectly meritorious issue that could have won the appeal, but losing because your trial lawyer forgot to say objection, hearsay, so the court reporter could type it down.
Okay, so the trial finishes. A verdict is reached. This brings us to window 3, which the briefing explicitly calls the most valuable, least used window.
This is the post-trial pre-appeal phase.
Right. The jury has gone home, the trial is over, but the appeal has not been filed yet. Let's walk through a hypothetical to really understand the pressure of window 3.
Okay, lay it on me.
Imagine a tech founder. Let's call her Sarah. Sarah just won a massive $50 million verdict against a tech giant for stealing her intellectual property.
A huge win.
Right. Her trial lawyers are celebrating, popping champagne. The CEO of the tech giant is furious and demands his legal team appeal immediately. The emotional load in both camps is at maximum capacity.
Neither side is thinking clearly in that moment. The tech giant's legal team is defensive and guarantees they will win on appeal. Sarah thinks her $50 million judgment is bulletproof.
And the briefing notes that Justice Aaron reported that most of the appeal-pending conferences she conducted actually ended in settlement right at this stage.
Which is fascinating.
Why? Because she acted as a ruthless reality check. She forces both sides to confront the standards of review we discussed earlier.
She would look at the tech giant's lawyers and say, you want to appeal the jury's factual finding that you stole the IP? You are up against the substantial evidence standard. The jury believed Sarah's expert. You have maybe a 10% chance of overturning that.
Brutal. And what does she say to Sarah, who is holding the $50 million ticket?
She tells Sarah, you have a judgment, but you have a 17% baseline risk of reversal. Furthermore, in California, the median civil appeal takes 1 to 2+ years.
Wow.
Can your startup survive 2 years of uncertainty while this is tied up in court? And remember, post-judgment interest is accruing against the tech giant every single day.
That daily interest accrual is a massive negotiating lever that a specialist uses to force a realistic settlement.
It changes the math completely.
To navigate this pressure cooker, the briefing provides an incredibly detailed 8-question triage checklist. A specialist uses this to diagnose the reality of the situation during window 3. Let's dive deep into these 8 questions and apply them to Sarah's hypothetical IP case.
Okay, let's do it. Question 1. Is the challenge order appealable at all?
Meaning what?
This is a strict jurisdictional threshold. The law dictates exactly when an appeal can be filed, usually only after a final judgment that resolves all issues.
Oh, I see.
If the tech giant tries to appeal a preliminary order before the final judgment is entered, the appellate court will throw it out as premature, wasting massive amounts of money.
Basically, are we even legally allowed in the appellate building yet?
Right.
Okay, question 2.
Is the issue legal, factual, or mixed? The specialist has to comb through the trial record. Did the tech giant lose because of a bad jury instruction, which is a legal issue? Or did they lose because the jury believed Sarah's timeline of events, which is a factual issue?
Which leads directly into question 3.
What standard of review applies? As we established, if it's a legal issue, you get de novo review, which gives you hope. If it's a factual issue, you get substantial evidence review, which is a near impossible hurdle.
Hold on. Going back to question 3 about the standard of review, if I'm Sarah, the CEO, I definitely don't know what standard applies to my case. How does the specialist figure that out in the heat of the moment when there are thousands of pages of transcripts?
That is where the specialist's pattern recognition comes in. They don't need to read every single page of testimony.
They don't.
No, they go straight to the jury instructions, the verdict forms, and the key motions. They can map the anatomy of the trial in a few hours and identify exactly which standard the appellate court will apply to the specific pressure points of the case.
That is incredibly efficient. Let's move to question 4.
If error occurred, was it prejudicial?
The harmless error rule again.
Exactly. The tech giant's lawyers might point to a moment where the judge wrongly excluded one of their emails. The specialist has to objectively evaluate. Did that one email actually change the jury's mind, considering the other 50 emails that did get admitted?
Right. Question 5.
Does the record overcome the presumption of correctness? In state court, if the trial record is silent or has missing transcripts, the appellate court assumes the trial judge did the right thing.
The tie goes to the judge.
Yes. If the tech giant's lawyers failed to get the judge's reasoning on the record, they cannot win the appeal.
If it's not on the transcript, it literally did not happen.
It didn't happen.
Question 6.
If there is no final judgment yet, is writ review realistic, or can the issue wait?
I want to pause on writ review because it sounds like arcane legal magic. Mechanically, what is a writ review and why is it used?
Well, a writ is an emergency petition to a higher court, asking them to jump the line and intervene in a trial before the final judgment happens.
When would you use that?
It is used when waiting for a normal appeal would cause irreparable harm, say, if a judge orders you to hand over highly confidential trade secrets during discovery.
Oh, because once they're out, they're out.
Exactly. However, writs are highly discretionary. The appellate court rejects the vast majority of them without even explaining why. Misjudging whether an issue is worthy of a writ wastes a ton of money and burns credibility with the court.
Good to know. Question 7 on the checklist.
Can the issues withstand the delay and cost of review? This is the business reality check. As we told Sarah, 1 to 2 years of compounding interest, appellate legal fees, and severe business disruption.
It's rarely just about the law. It's about the business.
Always.
And finally, question 8.
After a decision, is rehearing or higher review advisable, and on what grounds? If you lose at the Court of Appeal, do you try to take it to the Supreme Court?
The highest level.
Right. But the specialist knows the statistical odds of the Supreme Court even taking the case are minuscule.
So this 8-question triage forces pure rationality into a highly irrational, emotionally charged moment.
Exactly.
What about the final 2 windows of intervention? Window 4 is post-filing, and window 5 is post-briefing.
Once the appeal is officially filed and the settlement talks have failed, the specialist's role shifts to window 4, drafting the briefs. The briefing highlights a counterintuitive piece of advice from Judge Morrow and Justice Zillon.
Okay, what is it?
Appellate judges desperately want fewer issues raised in the briefs, not more.
But wait, if I am the tech giant who just lost $50 million, I am furious. I want my lawyers to tell the appellate judges about every single unfair thing the trial judge did to me. I want a 100-page catalog of grievances.
I know you do, but that scattershot approach is exactly how you lose an appeal. If you hand an appellate panel a brief with 10 different issues, they instantly assume you have no truly strong issues.
I see.
A specialist comes in, reviews the draft brief, and ruthlessly cuts the weak arguments, even if the client loves them, to elevate the 1 or 2 arguments that actually have a mathematical chance of success under the standards of review.
It is the brutal curation of argument.
Brutal curation, yes.
Okay, window 5, post-briefing, is the final stage before the judges make their decision.
This window involves moot courts, practicing the oral argument in front of mock judges. It involves oral argument triage. The lawyer only gets a very limited time, sometimes just 15 minutes, to speak to the panel.
15 minutes to decide $50 million.
Yes. A specialist helps the lawyer decide what single point to lead with, and critically, what points to gracefully concede to maintain credibility with the judges.
Conceding points is so hard for a trial lawyer. Their instinct is never to give an inch.
But an appellate specialist knows that conceding a weak point buys you the trust capital you need from the judges to win the strong point.
Okay, so we know when these specialists intervene, and we know exactly what they look for. I want to shift to exploring how their brains actually process this information differently than brilliant trial counsel.
Let's do it.
The briefing introduces a unique analytical framework called the 7 quotients, drawn from a 2026 manuscript by Russo. It maps sensory metaphors, eyes, ears, gut, heart, to measurable competencies.
It is a brilliant way to break down the anatomy of a neutral specialist. Let's start with eyes. This is mapped to IQ, intelligence quotient, and AQ, adaptability quotient.
What does that adaptability look like in practice?
It means the specialist provides a fresh, analytical reading of the cold record. Their IQ allows them to comprehend the immense complexity of the legal issues, but their AQ, their adaptability, allows them to completely discard the trial lawyer's original narrative and reframe the facts into exactly the structure the appellate panel wants to see.
So they aren't stuck on the old story.
Right. They adapt to the reviewing court's framework.
Next is ears.
Ears are mapped to CQ, curiosity quotient, and EQ, emotional quotient. This maps back to hearing the future transcript.
Right, the stage play analogy.
Exactly. They're curious about how a phrase will land in the future, and their emotional intelligence helps them anticipate the skeptical questions the appellate bench will inevitably ask.
Then we have GUT. The briefing maps this to PQ, practical or physical quotient, and FQ, focus quotient. I want to ground this one with an analogy.
Please do.
A trial lawyer might handle a few appeals in their entire career. A specialist has handled hundreds. It's exactly like an antique appraiser who specializes in luxury watches.
Oh, I like this.
An amateur might need a magnifying glass and an hour to authenticate a vintage Rolex. The master appraiser can spot a fake just by the weight of it in their hand the second they pick it up, because they have held 10,000 of them.
Yes, instantly.
Their gut is just highly compressed pattern recognition.
That is a perfect analogy for the FQ, the focus quotient. The specialist can look at a chaotic 5,000-page trial record, and their instinct zeroes in on the single fatal flaw that will sink the case, or the hidden jurisdictional gem that will save it long before they read every page.
It's like a superpower. Then there's heart. The briefing maps this to EQ, emotional quotient, and HQ, heart quotient. I found this surprising. Empathy in the middle of a ruthless, high-stakes legal battle.
It is arguably the most crucial quotient for the consulting aspect of the job. Go back to window 3, the post-verdict pressure cooker with Sarah, the tech founder. The specialist needs profound empathy to look at a victorious CEO who just won a $50 million verdict and tell her, you are at massive risk of losing this.
They have to deliver terrible, ego-bruising news to highly successful, powerful people.
They have to let a winner hear the risks of their victory and a loser hear the hard limits of their case without triggering defensiveness.
Which is incredibly hard.
If they lack the HQ and EQ to manage that intense emotional dynamic, the client will simply reject the advice and charge forward into a bad strategic bet.
The final piece integrates all of these senses.
Judgment, all 7 quotients integrated. This is the final, perfectly calibrated call. Do we try this case? Do we settle? Do we appeal? Or do we stand down?
Looking at this framework, it highlights how the act of advocacy naturally narrows emotional intelligence. When you are a trial lawyer, your empathy is entirely tuned toward what your client hopes will happen.
Right, you want to fight for them.
You absorb your client's anxiety, and you want to champion them. But the neutral specialist EQ is tuned to how the adversary and the judges will react. Their judgment is fundamentally better in this specific context, purely because they have no financial or emotional stake in the outcome.
They aren't blinded by the fight.
Right. They don't care if the client is mad at them for an afternoon, because their job isn't to be a cheerleader, it's to be compass.
As the briefing eloquently puts it, the value is not more knowledge. It is differently positioned knowledge.
So well said. Now, to provide a truly comprehensive analysis, we have to look at the other side of the ledger. When does hiring a neutral expert actually not make sense?
It's important to ask.
The briefing is very transparent about the counter case.
The case for restraint is real, and it starts by circling back to that base rate reality we discussed at the very beginning, the 70% affirmance rate.
If roughly 4 out of 5 California civil appeals end in affirmance, a competent trial team's default assumption that the judge's ruling will likely stand is mathematically usually correct.
Exactly. If you pay an expensive appellate expert, just to confirm the obvious, you are adding process, delay, and cost, but you are not adding actionable insight.
Which leads to the second point of restraint: cost and proportionality. Neutral evaluation is a specialized paid engagement. It is an additional layer of expense on top of your existing trial counsel.
If you are dealing with a modest stakes dispute, say a $150,000 breach of contract, the fee of bringing in a certified appellate specialist to analyze the record might completely cannibalize the expected financial value of the improved calibration they provide.
The math just does not work for smaller cases.
It really doesn't.
There are also mechanical risks to manage when bringing in an outsider. The first risk mentioned is privilege and work product. When you bring in an outside expert to evaluate your case, you are sharing highly sensitive confidential information. Draft briefs, candid risk memos, internal weaknesses.
This creates a dangerous risk that the opposing side could try to discover those documents in future litigation.
Like, they could subpoena your internal strategy.
Potentially. To protect the emails and memos, the briefing notes that it requires strict engagement structures or relying on mediation confidentiality to ensure that the candor is legally protected from discovery. You cannot just casually email an outside lawyer and ask what they think without considering the strict rules of privilege.
The final risk is what the briefing calls substitution risk.
A neutral evaluator is a supplement. They are a second set of eyes. They must never displace the merits counsel, the trial lawyer who is actually running the case day to day.
You can't have two captains on a ship.
Exactly. The trial lawyer carries the ethical duty. They know the full scope of the massive record, and they have to execute the strategy. If the specialist oversteps and tries to take over the wheel, it creates strategic chaos.
Synthesizing all of this, when is this consultation actually high value?
The briefing gives a very clear final synthesis. You bring in the neutral specialist when the financial or existential stakes are incredibly high, when the standard of review is highly contested or potentially favorable to you, when the trial record is extremely complex, when sunk costs and high emotions are visibly distorting your team's reality. Or, crucially, when you are in a post-judgment negotiation and you need a credibility anchor, a respected neutral voice, that both sides will actually listen to in order to force a settlement.
The briefing summarizes the ROI calculation perfectly with this line. The decision whether to consult is cheap to analyze and expensive to skip in high-stakes cases.
The cost of a few hours of an expert's time is negligible compared to a $50 million judgment going up in smoke, because nobody paused to ask the right question about the standard of review.
This has been a massive journey through the architecture of legal risk and human bias. We've explored the cold math of losing, the specific optical lenses of appellate review, the critical windows of intervention, and the sensory anatomy of a specialist.
A lot of ground covered.
But I want to leave you, the listener, with a final provocative thought, taking this out of the courtroom and into your own reality.
Applying the paradox to everyday leadership.
Exactly. Think deeply about that concept of listening to a present performance as a future transcript. Outside of the courtroom, in your intense board meetings, in your heated email threads with partners, in the critical life decisions you make when emotions are running hot and your own zeal is blinding you. Who in your life is acting as your appellate specialist?
Who is keeping you honest?
Right. Who is looking at your decisions without the zeal, without the emotion? Who is listening to the permanent record you are writing today and warning you how it's going to read to someone else a year from now?
It's a vital question.
If you do not have that person or that mechanism in your business or your life, you might be playing the odds without even knowing the rules of the game.
The advocate's paradox is universal. It is for anyone who cares deeply about what they are building.
It truly is. Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we refer to is published in detail and readily available, commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.